evidence that I objected to and you sustain our objections. It's now on the monitor pad for the jury review, so we would object to that. There wasn't any foundation there wasn't any proper foundation laid, and it's not relevant to the cross-examination of this witness since he has no personal knowledge about anything in the area.
Your Honor, it's not the same piece of evidence. This is actually the state's evidence 601, so I'm simply going to be confronting the state's expert with a piece of evidence, the state's evidence that's already in.
Well, hand that over to Mr. Evans so we can look and see if that's.
Right.
It's in Mr. Lynch's computer.
Okay. I'll assume, I have no reason to disbelieve that that's not that piece of evidence. Now let's get to the second part, though. How is it relevant? Even cross-examination has to be on relevant topics, and this witness having established on voir dire that he has no personal knowledge about anything from Google, has nothing to do, was not asked of looking at it, have a relevance objection to this being disclosed. And he's already been crossed about that.
It's about the very website that in his demonstration this morning, he testified that he actually visited this website. So
Which website?
I'm sorry, griffinpsychology.com. And so I'm going to revisit the piece of evidence, States 921, griffinpsychology.com, that was on their piece of evidence that they admitted on direct.
But it's on the Google website, right?
Yes, ma'am.
I don't see why I can't argue in closing argument about the significance of these types of things and use one piece of evidence against another piece of evidence, but it doesn't mean it's a relevant topic to cross-examination if a witness has no personal knowledge about that.
I'm going to look at the notes. You need to make a copy of what you're getting.
During the direct examination of this witness, and for the record, I was given a copy of States 921 this morning for the very first time. I'd never seen it before. There was an original report that was created by this witness in March 29 of 2016. By his own testimony, he came up with these pieces of evidence, turned it over to the state 48 hours ago. For the very first time, we're seeing it today. And so in my attempt to explore this piece of evidence that the state introduced, there was a side-by-side list of the contents of Chrome preferences, that's States 921. And I would specifically cross-examine him about why he selected this one website to make this example and demonstration to the jury, griffinpsychology.com. And he talked about how he even followed up, and I went to the website. Yet, all these other websites here, basecamp.com, DevTools, lesscss.org, Home Depot Dev, many of these websites that are listed on the right-hand side of the preferences that were allegedly cleared or deleted manually, those are web development websites. And so with this line of questioning, I would have the ability to impeach his credibility, bring it into question through a thorough and sifting cross-examination of a topic that they brought out on direct. and show the jury that he could have used any one of these web development websites to prove that, hey, the Chrome preferences have changed manually. But there's a very, very specific reason why he chose this one, because he wanted to put on this show about Dr. Jekyll and Mr. Hyde, and that, well, the suggestion is he went to griffinpsychology.com because he wanted to learn about jury trials. He wanted to plan, okay, for his involvement with the criminal justice system. Somehow the suggestion that he's researching how to deal with a criminal case. The fact of the matter, though, is that even in the state's own evidence, and I would submit that this piece of evidence that's already in evidence, I should be allowed, with a thorough and sifting cross-examination, to confront the state's expert with a piece of the state's evidence that's already in evidence. And it's not just some random piece of evidence, it's electronic evidence. And what is it? The griffinpsychology.com. And what it shows is that in May of 2014, there is a Google chat going on, and Your Honor may recall we've done a demonstration of this Google chat with two of the witnesses that have already testified, Mr. Alex Hall and Winston Millen. Those individuals, including Mr. Harris, were involved in creating a new business, Ninth Hour Development. And so they're talking about here adding griffinpsychology.com as a new client to their portfolio.
All right, I think we've only got to what the proffer may be. Now, what's this step?
I don't want to tell counsel how to do his job, but I don't have a problem with him asking, well, are there other websites that you could have looked at? That's a fair question.
Mm-hmm.
Are there other things that you could have looked at within the two screenshots that were put together and presented? But there's a different story altogether to talk about some chats between individuals that this witness has no familiarity with at all. What basically was expounded to the court just a moment ago was, I don't know, maybe a good argument for a jury during closing argument, but it's not the proper way to ask this witness about relevant information that's before him. I don't have any problem with him asking about anything that's on the pages in front of this witness in terms of other places that he could have looked to make the point that he was trying to make with this demonstrative aids. And I will respond to the first part that counsel said too. They've had this since 2014 whenever we turned over discovery. This is not something given them 48 hours ago. It's on the very Lenovo disk that they've now marked as Defendant's 85. The raw material to get what you need to for these demonstrative aids has always been available to them. This is not something that was merely provided to them 48 hours ago. What was provided was the demonstrative aids that came from that raw material.
All right, well, as to the proffer, and as to what I hear the intended purport of this examination relates to the business that was formed. We've had testimony on that from two of the people relevant to developing that business and what they were doing. They would be the proper people to testify about this. It would be hearsay from this witness, and I sustain the objection.
Your Honor, may I add one additional thing to my proffer?
Well, honestly, that could go on so forever.
It
Go
won't,
ahead.
it won't though.
Well, I know, but I know about walking in quicksand too.
Well, I don't, but
Well, you are.
I just
But I
want,
will let you.
thank you. I'll just point out that this one line here, I'll be removing unused CSS and JS tonight. That is directly related to the kind of activity that a web developer might engage in, which is the sort of suggestion that this witness has tried to explain means that he's trying to delete or hide evidence.
And who is the I'll be, I didn't write
Ross
that.
Harris.
Okay, that's from Mr. Harris?
Yes, ma'am. So it's not hearsay. These are his statements here.
That's not, this is not the proper witness to cross-examine on that. So I sustain the objection. So you might pull it.
Brian, can you pull it down, please?
Sure. Are you ready to resume, or do you need a minute?
No, I'm ready.
Give me a minute.
please.
You have to do.
Please be seated.
Mr. Rogers, proceed with cross-examination, please.
Thank you, Your Honor.
You're welcome.
You've been in the case for 30 months, is what you said, correct?
Yes, sir.
And how much are your fees?
I'm sorry,
How much are your fees in this case?
me personally or Pim Investigations?
You personally?
I might have made $4,500.
How much time did you spend in the case? Do you bill by the hour? How about that?
I do.
Okay. And how many billable hours?
As a company, we probably billed roughly 4 to 5 hours a month.
Okay. And who's in your company?
I'm sorry?
You asked how much you made personally or the company. Now I'm going to follow up. Who else is in your company?
My wife, and I've got a part-timer.
So how much did your part-timer make off of this case?
He didn't make anything.
Okay, so all the money that was generated in this case came to you and your wife?
No, sir, it went to the corporation. I get paid by the company.
You pay yourself?
Yes, sir, I am the chief executive officer.
You are PM Investigations?
Not as a single person, we are incorporated, as corporated.
So how many billable hours did you and your wife put in to the work in this case?
We averaged about between 4 and 5 a month.
And over the span of almost 30 months, your report was focused on 2 things: the red image and the vet video, correct?
Originally, yes, sir.
Well, it is late as March 29, 2016, correct?
As that report reflects, yes, sir.
There's no new report that you've created, right?
No, sir.
So everything that you've testified to, okay, all that was done after March 29, 2016?
No, sir.
You just decided not to put it in your report?
Again, it was late documents that came to surface.
You just waited until today, months after making this report, to let any of us know about it, right?
I didn't let you know anything. I let Mr. Evans know.
Thank you.
Redirect.
So all of the stuff that you brought to court, that came from the Lenovo extraction, is that correct?
Yes, sir.
Okay, so defendants 85, the Lenovo extraction that we looked at just a while ago, all of that information was available to them from their own exhibit, is that correct?
Correct.
You just went and added the arrows to show what the significance of it was about 48 hours ago?
Correct.
But the actual data itself, the information, the highest value, that was always available from the original extraction?
Correct.
You were asked about your work on this case and the number of hours. Is this the exclusive case that you've been working on since you were retained to assist us as a consultant?
Heavens, no.
And just give us a ballpark estimate, how many other cases you've been working on in addition to the state versus Justin Ross Harris?
in the last 30 months?
Sure.
Probably 25 or 30.
Okay. You know that among other things, the defendant is charged with criminal attempt to commit sexual exploitation of children and dissemination of harmful material to minors. Are you aware of that?
Yes.
Okay. Have you worked similar cases where you found that a person has deleted some information but not all of it?
Yes.
Can you explain?
I would object as to relevance, other cases.
Yes, sir.
Okay. Let me ask you about this particular case. Do you find it significant based on your training and experience that some information was deleted but not all of the pertinent information?
I do.
Okay, and explain.
Most of the time, when you're investigating, especially data, where there potentially could be law enforcement interacting with seizing and collecting the evidence, most of the time the defendant doesn't know that law enforcement's going to come and get that equipment. So they tend to delete things, or not delete things, keep things. So in this case, when you're looking for data where a person doesn't know that law enforcement's going to collect the equipment, and you see the internet history is completely gone, that's, in my opinion, somebody being prepared for not somebody like me seeing everything. So they go through the process of deleting, but leaving the other stuff behind to potentially have you go down that trail, go down that path, look at that information, focus on that. In my last 15 years, and I have trained countless forensic investigators, sometimes they just look at the data on the surface. They don't dig. They don't go to that unallocated space. Why? It takes effort. It takes a lot of work. It takes time. Data doesn't just jump out. But if I look on your desktop and I can see something, generally I stop my investigation. So you have to learn to dig further. So in this case, when you evaluate the history of one and the history of another, and even on the iPhone where it's limited of what you have on those 2 days, raises the bar of suspicion.
And when a person is assessed with something, such as sexual type of content, is it uncommon based on your investigative experience that they would not delete all of that?
Yeah, it's very common that they won't go through and delete it. Why? A lot of them, we refer to them as collectors. They don't want to have to go back out and get it again. Run the risk of getting a trigger where maybe law enforcement is doing an online investigation. You know, we watch some of these TV shows, To Catch a Predator, for example, and yet they still do it. So when we're looking at the data, we know that, again, most of these people, they don't want to lose what they have. They'll actually move it to a thumb drive, or they'll move it and burn it to a CD-ROM, or, we've even had cases where they'll upload it, to a cloud service because they want to keep it, they want to hold on to it.
Or even move the application that may, so it's not readily visible when you power on the phone if it sees.
Absolutely. Again, what most forensic specialists like to start with is looking with the naked eye can see, not necessarily the forensic eye. So if you've got to start moving the tiles around, you've got to start opening up folders, you've got to start taking something that was encrypted and decrypted, you've got to do a recovery. It takes time. It takes work. It also takes a special set of skills to figure out what somebody may have had a computer. Let's say they've had that for 3 years, and I spend 5 hours a month looking at that. I'm never going to catch up to their use.
Now, this jury's already seen, and I believe I showed you during the break, the actual phone itself when I powered it on and showed where the Whisper app was inside a weather icon. Do you remember that?
I do remember that.
Okay, so I want to ask you about that. How does that view differ from, say, a mere Celebrite pull from a cell phone? Give us an analogy that will explain how Celebrite's not going to give you the full picture unless you go and look at the handset.
It's a great question. Take a deck of playing cards. We know that there's 52 and 2 jokers. Brand new deck, you open it up, most of the time the 2 jokers are right there on the top. You know that. You take one of the jokers and you slide it in the middle. You don't know where it is, you just slide it in the middle. You put the deck back in the box. Now only you know that you slid it in the middle like that. Here comes Celebrite, or I take that same deck of cards, I open it up and I put all 52 plus the 2 jokers on a table, and I just scan them off the top of one another. Then I flip them over and I realize I have 54 cards. That's what I expect to see. I don't know that the order has changed. That's the difference with Cellebrite. Cellebrite lets you see the folder structure just as those cards are laying on a table. They don't see that the joker has been slid in the middle of the stack.
Okay. Let me ask you about what was provided to you in terms of your ability to conduct your more limited investigation in this case. Were you satisfied with what Cobb Police gave you in terms of the extractions?
No, I had to ask for more.
Okay. And when you were asked for more, did you get exactly what you asked for so that you could complete your investigation?
I did.
Okay. Just give an example. What did you ask for that you wanted that you thought would be more beneficial than the initial extraction?
Well, what Cobb High Tech did, and did well, is that they use an application that's made by a company called Magnets, Internet Evidence Finder. Well, it gives me the results of what that forensic tool found on these devices. But I wanted to dig deeper. So I asked for forensic images of the computer hard drives. Those are what we call EO files. Just in layman's terms, what that basically means is a bunch of files all compressed together will match exactly the hard drive. I needed that to explore deeper. The Internet Evidence Finder won't always give you data from the unallocated space. It'll give you some of it, but it won't give you all of it. I wanted to search those areas. So I asked for copies of the forensic images, and they provided.
I want to ask you a little bit about what we initially asked you to focus on. Is it uncommon for somebody to retain your services and have you start at building block A, a more limited point, but then ask you to expand your work?
And it happens all the time.
Is that what happened in this case, or as defense counsel asked, were you only asked to look at two areas to the exclusion of all others?
No, it expanded. We had 3 blocks, A, B, and C, that we were working from. We're now in X, Y, and Z. We kept building those blocks of requests.
The point that he focused on in terms of the initial reason that you were engaged to come and assist with this, admittedly, was that for a more limited purpose at first?
It was.
Okay. By the end of it, had you been asked to look at a number of things, including some of the things you testified about here?
Yes.
Staying on that topic of being retained and working with law enforcement and support capacity in this case, you're asking questions about meeting with Detective Stoddard. Was he the exclusive person you met with, or who did you have most contact with?
I had most contact with you. There was handfuls of people at times in present.
Were there times when there were actually group meetings where maybe Stoddard was present or even not present?
Yes.
When it comes to your review of the extractions, and you're asking questions about one extraction versus another, until you look at that extraction, are you going to know what's on it?
No.
Okay. And if you found a video on one extraction, would that mean that you wouldn't look at the others as well?
No.
Okay. Explain.
Here's the thing that we've learned, especially in cases that I've dealt with that deal with child pornographers. They will take data, download it.
Object to testimony about child pornographers. That's not relevant.
This is done.
Okay. Yeah, go on. All right, let me ask you a question about this post that the defense counsel brought in. This is an important point. The age of consent. This is specifically looking at Defendant 71. They're talking about a post. A couple points here. First of all, this is dealing with statutory rape, I believe, correct?
Judge,
Yes.
I'm going to object to leaving.
Okay. What's the topic?
That's correct, if you can read that. Go ahead.
What's the topic that's addressed here? What crime?
Statutory rape.
The age of consent for statutory rape, it's different than exploitation of minors,
Judge,
correct?
I'm going to object to that question and ask for a legal opinion.
I sustain that objection.
Go on to this topic. You're asked about the iPhone 5 and the dates where search activity could be seen, correct?
Yes.
Okay. And the 2 dates that are remained in terms of the browser search activity were what dates?
It was June 17th.
Mhm.
And we saw parts of June 6th, 13th.
And that's part of the question. So in terms of the browser activity, that only showed activity from the 17th and 18th. Look at this post here in Defendant's 91 and tell me the date of that.
February 19th, 2014.
Okay, so this involves something that was researched back in February, even though it was not included in the browser data that was from the 17th and 18th, correct?
Correct.
In other words, you could look to other areas of the phone to see if there had been prior searches, even though it may not have been deleted from the search history.
Yes.
And does the absence of you finding a search, we use the iPhone 5 for example, mean that a search was not conducted?
No. In fact, we talked a little bit about unallocated space. It does fill up. So what happens to the data that fills up? In layman's terms, it falls off the edge. In technical terms, it's what we call overwriting data. If something is overwritten, I take this document and I overwrite it with another document, I can't always see what's under it. That is truly deleted beyond recovery, overwritten. And where does that exist? Unallocated space. So when you delete something and it goes out to unallocated space and it gets overwritten, none of us in this room are going to be able to do anything with it. We can't recover from that. It's gone.
And if we use this as an example, go back to Defendant's 91. Had the defendant not used or taken a screenshot apparently of this statutory rape statute, we wouldn't have found that this was searched because the search history was deleted prior to the 17th and 18th, correct?
Jack is deleting.
I'll try to rephrase it. Would you have found this if that history was deleted?
I would not necessarily have found that if it wasn't already captured. Now, part of that is we have to understand the difference between the iPhone and a computer. Unallocated space is going to be much larger. City of New York, more people, more spaces. The unallocated space of an iPhone, very small town worth, very limited. Therefore, you're overwriting data faster than you are with a computer.
Thank you, sir.
That image, D91, he didn't delete it from his phone, did he?
This image he didn't delete. However, this image is a thumbnail. You see, the difference between an actual photograph and a thumbnail. Thumbnail is a very small picture. The big picture that you see results in this thumbnail getting created. It does that for two reasons. Number one, the next time a person wants to see it, it loads faster because he's pulling from this thumbnail. Number two is it creates a record so that if you wanted to search something similar, it could draw from that. So this being a thumbnail, he wouldn't have access to that from his iPhone to delete it. The actual picture itself, he would. The thumbnail is in a small little database file that holds this information. He can't just go into it and delete it. You can get some tools that you could download and go through and probably scrub that database to get rid of it. That didn't happen in this case because it's still around.
You didn't correct Mr. Evans when he asked you and referred to that piece of evidence as a screenshot. Are you now saying that it's not a screenshot?
I'm saying that I can't tell that because I need to see closer here. However, it says at the top of this second page that it's a thumbnail. What I can't see, because the print on the second page is so small, I have blue down here at the bottom that might be a number that I can't see in the thumbnail.
It might be a screenshot, right?
You talk about the thumbnail, is it a screenshot?
That photograph there. It might be a screenshot if he actually took on his phone and saved as an image on his phone.
It could be, yes.
When Mr. Evans asked you about that screenshot, you didn't launch into this explanation about how it's a thumbnail and it may not be an image that he took, right? You didn't do that.
I don't know if you're talking about a forensic image or you're talking about a photograph image. If you could clarify, please.
I'm just trying to, let me just be plain spoken with you. There's a lot of photographs on his phone, correct?
Yes, sir.
Did you look at them?
Not all of them, no, sir.
Okay. There's a bunch, right?
There is a lot, yes, sir.
and no evidence that he was systematically trying to delete the filthy images that were saved on his phone, photographs that were saved on his phone, correct?
Correct.
You would agree that a web developer that uses Google Chrome exclusively as a web development tool, okay, there's a perfectly good reason for why they would clear the cache, correct?
That would call for speculation, so I would object.
He's an expert in electronic evidence. His testimony is that because Mr. Harris cleared his cache only on Google Chrome, that there must be some nefarious reason for it.
I just think it's an awful broad question.
If you knew that a web developer was clearing their cache only on Google Chrome, because Google Chrome is what they use for web development, that's not some unusual reason to be clearing the cache, correct?
If I said yes to that, I might agree a little bit. However, the video of the dog is in his Chrome, and it wasn't deleted. What that has to do with web developing, I don't know. If it were in his Firefox, I'd understand that. But it's in his Chrome. So that doesn't tell me that he's using that exclusively for web developing.
You could use Google Chrome for your web development purposes and not clear your cache every single day, right?
As well as with Firefox, yes.
There's no evidence that he was trying to hide any of his activity on Firefox, right?
I do not see that, no.
Okay. And you have no way of knowing, okay, why he chose a day in particular to clear his cache or not.
I do not know why, no, sir.
Now, you believe it's suspicious because he deleted his cache, correct?
I do.
Now that you know that he's a web developer and there's a perfectly good reason for him to clear his cache, you think it's suspicious that he didn't clear his cache in Firefox?
Absolutely. In fact, because I build websites too, I manage all of mine, and I've built them over the years. I frequently will install on a computer both Firefox, Chrome, Internet Explorer, Microsoft's latest Edge. Why? Because as I'm developing a website, I want to see how it looks in all the browsers, because they all treat that website differently. So in this case, yes, it's extremely suspicious to me that you have one browser where he clears his cache, the other one he leaves it intact.
You also thought that it was extremely suspicious that he went to a website, griffinpsychology.com, and then it was deleted from his Google preferences, didn't you?
No, sir, it's not deleted from the preferences. That's where you're mistaken. It's actually changed names. It dropped the www dot in front of it. It's on both sides.
You thought that him visiting that website was extremely suspicious, correct?
I knew nothing of the history of that website. So I seen that particular website as a site that he had accessed, that he had control over, that he was clicking on. That's how it ended up in his favorites, which is no different than private internet access. He's accessing it.
And of all the websites that you could have used as an example, you chose that one because you thought it was extremely suspicious, correct?
No, it was the only one I thought I was unfamiliar with.
Right. And you familiarized yourself with that website, correct?
I absolutely didn't know what it was.
You went there,
Yes, sir.
right? And you thought it was important to tell this jury some of the suspicious things that you found on that website, correct?
Yes, sir.
But you didn't take the next step and check with Mr. Evans or check with the other evidence that you were provided to see, is he actually a web developer for that website? You didn't do that.
No, sir, I thought he was a web developer for Home Depot.
Because you didn't know that he was starting a new business, correct?
Correct.
You didn't know that that new business was a web development business, correct?
Correct.
You didn't know that they had plans for the future beyond June the 18th, 2014, correct?
I still don't know, sir.
No. But you could have found that information out if you had looked at all the other activity on his devices, right?
I could have, but didn't.
You didn't.
Because this morning, I thought, between you and Mr. Evans, would ask a question if I knew anything about that website.
And before I was given an opportunity to ask you a single question, you were corrected, and you came back after the break to specifically make clear to this jury that what you originally found is very suspicious. There's a perfectly good reason for him to have had control over that website, correct?
I can't say there's a perfectly good reason for it. I don't know why he chose to work with that company. I don't know that. I do know this. I've built sites for plumbing companies, air conditioning companies, and guess what? When my air conditioning goes out, they're the ones I call. I know that factually. So I don't know what his relationship is with them, but I use that as a marker in the preferences because we could see that something had changed in it. It dropped the www versus the other, private internet access, wasn't in there. That was the point.
Now that the district attorney's office has made you aware that Griffin Psychology is a client or was a client of Mr. Harris, do you still think it's suspicious that he was doing some web development work on the side? Is that suspicious?
I have to object to that. Mischaracterizes the testimony. He has said that it's suspicious that the defendant happens to do web development. That's not what the testimony's been.
He has some on us.
I want to ask again.
Please.
Now that you were made aware by the district attorney's office that Ross Harris worked as the web developer for Griffin Psychology, do you think that's suspicious?
No, but I do say this. Puts him in control of his preferences. So those 2 dates of the history being deleted certainly is his ownership. The fact that privateinternetaccess.com was added as his favorites is certainly pointing to him.
Did you consider the possibility that private internet access was something that Ninth Hour Development, his new business, would want to use? Did you even consider that?
No, in fact, I consider if they're web developers, why wouldn't they make their own?
When I asked you how much you had been paid, let me clarify. How much did your company bill for this case?
Approximately $31,000 over the 30 months, about 5 hours a month.
So, admittedly, I should have followed up with another question. But you had only paid yourself and your wife $4,500. Is that close enough?
Approximately, yes.
But now we know that your company actually billed what, $31,000?
That's correct. Let me add to that, the Celebrite license itself, just to buy the software, the hardware dongles that come with it, $6,300 on renewal. It's just that software. That's not including in-case. That's not including the rent. It's not including anything else. So yeah, that's about what we bill.
For 4 hours a month?
About that, yes, sir.
And Celebrate, the software that you're talking about as being expensive, Cobb County Police, they have that, right?
They have their copy, but it's ran by what's called a dongle. Might be a new word for you as well. Dongle's about the size of your thumb. It's like a USB drive. You have to plug it in the computer to get it to work. When you buy a copy, you get one. That means I run it at my lab. If I want to run it at your house, I got to take the dongle with me. The one at the lab isn't going to run anymore without that dongle. Cobb County Police might have one dongle. All the cases they get involved with, they've got one dongle. They can't give me the dongle, and I certainly can't sit down there and do my work, not without running in interference with the rest of their cases.
That's all I have, Judge.
No.
Next witness.
Judge, I ask that the witness not be released, just be subject to recall, please.
Should we fresh talk schedule real quick?
Can the witness step in?
Yes, ma'am. Dustin?
You solemnly swear affirm the testimony you shall give to the court, so help you God, the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
Please be seated.
So if you will, we'll use the microphone the best you're able. Introduce yourself to the jurors and spell your first and last name.
My name is David Dustin, first name D-A-V-I-D, last name D-U-S-T-I-N.
And Mr. Dustin, where generally do you live? We don't have to have an exact street address, but where in the state?
Adairsville, Georgia, sir.
And I want to ask, where are you employed?
I'm self-employed.
And what's the company that you run?
I run a company called Dustin Forensics
And how long have you run Dustin Forensics?
since about 2002.
Okay, so that's been up and running for some time now. I want
Yes,
to
sir.
talk a little bit about what you do specifically at Dustin Forensics. Can you articulate for the jury?
Yes, sir. So we specialize in 3D laser scanning or other methods of data capture. We do a lot of training for law enforcement, a lot of training for like forensic engineering companies, things like that, that want to use the technology to be able to capture data. And so for instance, in the example of the the forensic engineering companies. So if they have a bridge collapse or something like that, they want to be able to analyze this, use the data to be able to analyze perhaps a structural failure. And as it applies to law enforcement, they use it for the mapping of crime scenes and then also for crash scenes. Those are the two most common applications of it. And so we instruct agencies and companies in the use of the technology and then also the software. I've trained approximately, I would say at least 60 individual police agencies across the nation on how to use this. We've done advanced training. We've trained agencies, military agencies. So we've done training for the U.S. Army, for NCIS. We've done some things with the Army, but I don't remember how in-depth it was.
And what sort of training, education, and background do you have that qualifies you to both do these 3D crime scene mappings and then also train other agencies on how to use them?
Right. So training, I came out of engineering. I had a very in-depth background in machine controls. So things like robotics and automated machinery. So I would design equipment. I would also program the equipment to function a certain way. And then as far as education, I've graduated high school, a small city in Wisconsin. Interestingly, I served a 4-year apprenticeship to become a journeyman, maintenance mechanic, pretty involved. And then I did some education related to, it was an associate's degree for something called electromechanical technology, which is basically robotics.
And then I want to ask you about the background specifically tailored to 3D crime scene mapping, and I want to talk to you about Pharaoh. Are you familiar with the Pharaoh mapping software and mapping equipment?
Yes, sir. So I purchased one of the first units that Pharaoh, which is a U.S. held company, purchased one of the first models. It was easily one of the first 50 in the nation, and we were one of the first 4 or 5 that used it in any kind of forensic application. When we started, there was, and I don't mean to use the pun, but when you do a laser scan, it captures a lot of data points. Well, when we started, there really wasn't much out there for how to apply this technology. So we were able to
We developed our own software plugins for the other software that we used. I developed an iPad app to be able to visualize the image exports from the scan data. Very popular with law enforcement and also engineering companies, things of that nature.
And the Faro Technology, once you purchased it, that began a long-term relationship between your company and Faro, the company that actually creates the 3D mapping equipment.
Yes, sir. So because of that, because of our early involvement and learning everything, there was, I shouldn't say everything, but a good share of what the equipment will do and what the software will do. Then, and we're also a beta tester, so when there's a new piece of equipment that comes out, we field test it. We also are beta testers for the software, have a very in-depth relationship with both the developers of the hardware, and then also the developers of the software. I probably communicate more with the software developers at least once a week, introduce or explaining different bugs that I may have found in the software. So it's a very very close relationship that I have with the manufacturer.
And is that the equipment, among others, that you are training law enforcement around the country how to use?
Yes, that's correct.
As one of the agencies that you've trained, Cobb County Police Department, based on your work with them on this case and some other cases.
Yes, sir. I've trained Cobb County in the state of Georgia. Let's see, I've trained Pooler, I've trained Warner Robins, I've trained Cherokee County, Cobb County. I thought there was one more in there, but yes, sir.
What about some of our federal agencies? And because we're in Glenn County, I'll ask you specifically about NCIS.
Yeah, spent quite a bit of time with NCIS. Actually worked with them on at least one case. I actually did all of the laser scanning, and this was a drive-by shooting case. And so I did all of the laser scanning, all of the post-processing, created the deliverable that they could take to their court system. I also helped them on another bullet trajectory case, some dwelling in Quantico. So, and I've trained NCIS on, I want to say, for sure twice, and then perhaps on 3 different occasions, and then also some of them have attended some of my advanced training classes.
So in addition to the training, in addition to the individualized work that you've done, have you testified as an expert in 3D mapping and forensic crime scene mapping using this 3D laser technology before?
Yes, sir. So I've testified, I've been identified as an expert here in Georgia, also in the state of Tennessee. There was one more that I had actually forgotten about, only because I think I said my name and yes, but that was in Texas, Longview, Texas. I was attending a hearing down there. We had used some laser scanning technology to scan an underground bunker for, it was a doomsday prepper, and there was a homicide.
Okay. And in fact, in the Georgia case that you referred to, that was a case that was prosecuted in Cobb County. It was a murder case as well. Is that correct?
Yes, sir, that's correct.
And you were tendered or received as an expert in 3D laser scanning and crime scene mapping?
Yes, sir, that's correct.
At this point, Judge, I tender David Dustin as an expert in 3D laser scanning and crime scene mapping.
And then he can testify as an expert.
Ask you a little bit of background before we get into the technology, and you understand we're going to have to break up your technology. We're not going to be able to finish this today.
Yes,
but
sir, I
we'll
understand.
get into it as far as we can. So I want to ask you this. Can you tell me, first of all, does your son work with you?
Yes, sir, he does.
Okay, his name's already been raised during this trial.
Yes,
His
sir.
name is Eric Dustin, correct?
Yes, sir, that's correct.
In addition to the 3D scanning, which is the primary purpose of your company, do you sometimes assist law enforcement agencies with other requests, such as the GoPro videos that were seen by this jury in this particular case?
Yes, sir. Actually, we do a lot of support, all pro bono, for agencies across the country, anywhere from NYPD. We had done their training, and then we have assisted them from time to time. We had worked on a case out in, I believe it was Salem, Oregon. This was during a training exercise. They had a homicide. We scanned the project. Effectively, I completed the entire project and deliverable that they used for the grand jury hearing for that particular case.
All right.
And my gosh, many many other agencies across the country, my phone rings a lot.
Most of your company makes money by doing the training, is that correct?
For the most part, yes, sir.
But in this particular case, since I know the defense will likely ask it, you're performing your services pro bono, just as you did in the other homicide case?
Yes, sir, that's correct.
Okay. I want to talk a little bit about the scanning process in general, and would it help you in explaining the process? We actually showed them what the Faro laser scanner looks
Yes,
like.
sir, I think it would.
Why don't you step down? I don't want to break your equipment, so I'm going to ask you, I'll help you if you need it, but mostly I want you to move your expensive equipment, so we don't suddenly leave pro bono and become paying customers. I want you to try to explain in layman's terms what 3D scanning and 3D crime scene mapping actually is. And you have, for the record, a device in front of the jury now. It's called the Faro 3D scanner.
Yes, sir, that's correct.
Okay. What is it that we're able to do when we do 3D crime scene mapping and 3D scanning?
Right, so inside of this device, it's a handy little, it's very light, you can hold it with one hand. Inside of this device, there's a laser, and amongst other things, there's a GPS sensor, there's something called an inclinometer to check its level. But there's a laser in this side of the cabinet. There's also a camera. So what happens is the laser emits a beam and this mirror spins. Okay? So as that mirror spins, it's basically painting the area with light. So anywhere that beam touches, it will stop and it will come back, it will return to the scanner. The scanner calculates the distance based on the constant of the speed of light. Okay? So that returns to the scanner. So while that's happening, the base of this scanner is rotating also. So what it does is the base rotates 180 degrees, and then when it's finished, because it's scanning out both sides, it has a complete 360 degree, I think it's actually 362 with overlap, sorry. So it has basically everything that it can see in a direct line of sight. It has some limitations, so it cannot see through things. It's not an X-ray machine, right? So and it's also, you know, it struggles with certain things like glass. So as an example, if you remember from some of your high school classes, what happens to light is when light hits glass, it slows down. Okay? So light moves about 300,000 kilometers per hour, I believe. When it goes through glass, it slows down to about 200,000. So glass presents a problem for laser scanning. It's just part of the technology.
Now,
all of them.
I want to ask you some of the terms. You talked about line of sight and the importance of accounting for line of sight when we scan a scene.
Yes,
When you say line of sight, what is it you're referring to, and how do we account for issues that you might have for items that are not within the line of sight?
Right. So line of sight just means that if it is not, I don't want to use acuity terms as in like for optical for our eyes, but if the scanner can't see a point, then it can't record it. So what we do in that instance is we'll take the scanner, we'll complete a scan. Now, I forgot the second portion. Once it's finished doing the laser capture, then what happens is the mirror rotates again, and the camera, there's a camera inside of this housing, and the camera snaps images. So it captures a series of 85 photographs, and then it stitches those together into what's called a panorama. Okay? And it then takes that color, and it applies that color to the scanned dots. So for instance, then this banister, because it's a certain shade of brown, the camera has captured that, and so it assigns that color value to that particular point in space.
So the electronic scans, it meshes with the photographic evidence, so that the scans actually incorporate the colors that are being scanned as well?
That's correct. So, and there's also a void below the scanner. They call it the nadir, or a void below the scanner, because it can't see through itself either. So you'll see a circular void below the scanner. So then what we do is, in order to capture more efficiently, or more effectively, I should say, the data, you'll move it to another position and you'll perform another scan.
And why do you move it to another position? Use this podium as an example. Would you expect to catch anything on this side of the podium?
Right. So if we scan from this position, there would be a void behind that podium because the scanner can't, I don't want to say see, but it is not able to detect any information back there. So what we would do is we would move it to another position, and we would scan again, and this time filling in that additional void. Now we can also do, because it's so small, we can actually take it off of here. Say there was evidence or something under the table, you could actually place it down on the floor as well.
So you don't have to use the tripod, in other words.
You do not. You could also invert the scanner and put it down into a hole if you needed to.
And it still, you'd use the same process
Yes,
to create a scan?
That's correct.
Okay. And for some, I'll call them more involved scenes, like an outdoor scene, is it sometimes necessary to take multiple scans from multiple locations within that scene?
I would say the largest scene I've ever scanned, we did approximately 70 scans. It was a downtown area.
And then let me ask you this, what about smaller scenes? How small can you get with Faro technology? Is there another handheld device that can sometimes assist?
Yes, so you can do tighter environments with this type of a scanner. It isn't the best suited for that, so we have another type of device. We have another type of a device called, it's called the Freestyle, is the product name for it, but it's typically just referred to as a hand scanner. And so the way that you operate it is you power it from this Windows tablet, and then the scanner itself, so this is not a laser scanner, this is something called the structured light scanner. So what it does is it projects an infrared pattern of dots, and it's got an infrared camera that can see those dots. And what it does is it interprets those dots and how they are conforming to an object, and because it can view them from two places, then it can triangulate those dots. Okay? So it's a very handy way. It has some of the same limitations. So because it's using light, it still has issues with items that are reflective, or items that are, where it could cause refraction or something like that.
Okay. But using a device like this for a more enclosed space, it's very similar technology, would you agree?
It's similar. It's just not a laser. It's structured light.
Okay. Using this smaller handheld technology, is that what you refer to as the handheld?
Yes, sir.
Could you scan a smaller scene as well as a larger scene using the Faro 3D scanner?
Yes, sir. And then you can merge the data together.
Great. That's my next point. You can set that down wherever's convenient for you, Mr. Dustin. I want to ask you about merging the data, and I want to ask you about a term that you use called stitching. So, yes. Let's talk about merging the data and stitching. You're familiar with those two terms, and you and I have discussed those in the past, correct?
That's correct. So there's a term called registration also. What registration is where you take individual scans, and when you first perform a scan, each individual scan has its own coordinate system. Okay? And so in order for these scans to work together, you have to combine them to a single coordinate system. So the software will perform what's called registration. Think of it as pieces of a puzzle. Okay? So if I've done 5 scans, I've got 5 pieces of a puzzle. Okay? Each one shows a different area of the environment that you're trying to scan. The software will analyze that, and it will determine how those scans fit best together, and then it will register them.
And then I want to talk about, what's stitching?
Stitching can apply to a couple different things. Usually we just refer to it as merging.
Okay, explain merging.
Okay, so merging is where you would have different scans, and then you could merge them together. So as an example, I could take a scan of that podium, I could isolate that, I could merge that into a different set of scans if it was advantageous or required for a certain process.
All right, and then let's talk about how the actual scans are displayed once the scanning process is accomplished.
Right, so the software itself allows you to visualize the scan. You can maneuver, if you will, through the laser scan data in 3D space. so you can move behind, over, behind, or around objects. You can also perform measurements in the scene, so it isn't unusual to pull measurements from this laser scan data.
All right, and let's talk about what you did in this particular case. Before we get to that, I want to talk about a scan that you had accomplished in this particular courtroom. Did you
Yes, sir.
ask somebody that you trained and worked with to scan this courtroom so we could demonstrate the technology?
Yes, sir, I did.
Judge, do you want me to continue on, or
How long is the next piece going to take?
it's going to go over 4:30, probably?
How much?
Give me 15 minutes. How about that?
No, I'm being realistic. I'm not.
4:45?
4:45?
Yeah.
Well, let me be more professional.
I-
No, thank you.
I'd rather give you a higher than a lower and get in trouble, Judge, so.
Well, you wouldn't get in trouble, but I appreciate
Yes, ma'am.
that you would approach it that way, because I think that's a very valid way to approach things.
Thank you, Judge.
And I take back the "nah," and I say no. No, we're going to close our notepads, keep an open mind, no conversations at all with anyone in any way whatsoever. As you know, the evidence will come to you from the witness stand, so don't explore anything else whatsoever. Have a very pleasant, lovely evening. We'll resume at 8:30 in the morning.
Please watch your stuff going down.
When you said 15 minutes, I was thinking 4:35, and then when you said the other one, nah.
Yes, ma'am.
Yeah. Everybody, have a good evening. See you.
Thank you, Judge.
Judge, I wanted to perfect something on the
Please
record.
do.
I can do it now or in the morning, it's up to you. Okay.
What would it be, sir?
I just wanted to, I guess, either renew or perfect my motion for mistrial this morning. In particular, I want to call something to the court's attention. The court indicated that the jury had a right to view a piece of evidence. This evidence that we're talking about, that I made a motion for mistrial on, is State's Exhibit 650. That is, says defendants, Hyundai, Tucson. But that's not what the jury saw. What the jury saw was a manipulated piece of evidence. It wasn't just the Tucson. What happened was another piece of evidence, the car seat, was then placed into the vehicle. So they weren't just seeing the Tucson. They were seeing it manipulated with another piece of evidence that was put in there. And that's why I stress to the court, it's absolutely a recreation, because now we're putting together two pieces of evidence for the purpose of seeing them combined and together. For the reasons that I went over this morning, I believe it was a wholly improper recreation and procedure that has caused Mr. Harris not to have a fair trial in this case. And I believe his rights to a fair trial have absolutely been abridged by that recreation procedure that we did. So I just wanted to perfect the record on that basis, if I could.
Thank you, Mr. Kilgore. Yes, sir.
Nothing.
One additional matter, I want to perfect the record on the scan, the motion in limine that we filed regarding this new piece of evidence, that being the scan that the state is going to be showing us tomorrow. I just want the record to be very clear. The motion that we filed was a motion in limine to exclude a piece of evidence that we got mid-trial. And although we made a proffer yesterday as to that, we'll make sure the court understands, the court has not seen that evidence. It's never been shown to the court, and that's why we have been requesting to take evidence directly from the creator of that scan and allow the court to actually see the scan. And again, I know that Mr. Rodriguez made a proffer, but I wanted to make sure that the record was real clear to that extent, Judge. So that's all I want to put on the record. Thank you.
Well, the record stands eliminated by Mr. Kilgore's comments.
Thank you, Judge.
Yes, sir. Go back to you, Money. Everybody have a good evening.
Thank you, Your Honor.
Thank you, Your Honor.
Something I'll get for the minute.